Everyone ready? Yes, Your Honor. All right. Let's go on the record. This is case CR 17-17, State of Nebraska versus Patrick Schroeder. Appearing on behalf of the state are Mr. Smith and Special Deputy County Attorneys Mr. Warner and Mr. Guinan. Sarah Newell and Todd Lancaster appear with the defendant. We're here because on a hearing held in late July, Mr. Schroeder, you told me that it was your desire to waive your right to a jury trial on the issue of the aggravating factors. And I told you that I wanted you to think about it and talk to your attorneys before you proceeded. Mr. Schroeder, what is your request?
Same thing.
All right. When I saw you a few weeks ago, I asked you a number of questions about your educational background, your understanding of the judicial system, any medical problems or psychological problems that you may have had in the past. Have any of your answers to these questions changed?
No.
Are you currently on any medications that might affect your understanding of what you're doing here today?
No.
You have pled guilty to murder in the first degree and use of a weapon to commit a felony. On the murder charge, there are two possible sentences. The first is life in prison. The second is the death penalty. The state of Nebraska is asking for imposition of the death sentence in this case. Do you understand those possible penalties on the murder charge, sir?
Yes.
In regard to the murder charge only, sir, the next step is normally the convening of a jury to decide whether there is evidence of aggravating factors. That means reasons to impose the death penalty. If those aggravators are proven by the state, then the Chief Justice of the Supreme Court would appoint a 3-judge panel to decide whether to impose the death penalty. If you waive that jury, sir, the next step is the convening of the 3-judge panel, which will preside over both the aggravation and the mitigation portions of the hearing. Do you understand the way those two procedures differ?
Yes.
As we've previously discussed, sir, my job is to be neutral. That means if you waive a jury, sir, I will be one of the person that decides whether the state has proven its case, rather than a jury. Do you understand that?
Yes.
Mr. Schroeder, in regard to your right to a jury trial on the issue of aggravating factors, do you wish to have a jury trial or do you wish to waive your right to a jury trial?
Waive my right to a jury trial.
Once again, sir, do you think you're clear-headed here today?
Yes.
You think you understand what we're doing?
Yes.
Have you discussed this decision with your attorneys?
Yes, I have.
Have you discussed it with any of your family members or any other close associates in whom you have a good deal of trust?
No.
Are you certain that this is what you wish to do?
Yes.
Has anyone made any threats of any kind to get you to enter into this decision?
No.
Has anybody promised you anything to enter into this decision?
No.
Are you making this decision of your own free will?
Yes.
You think you understand all of the consequences of this decision, Mr. Schroeder?
Yes.
You have any questions of me before I accept your decision?
No.
You think you fully understand everything that's going on here today, Mr. Schroeder?
Yes.
Court finds that the defendant's waiver of his right to a jury trial on the issue of aggravating factors is made freely, voluntarily, knowingly, and intelligently, understanding the consequences thereof, which the court accepts. The court further makes this finding beyond a reasonable doubt. Well, I need to order a pre-sentence investigation report, which I will do, and then I will contact the Chief Justice to appoint a 3-judge panel. I will set those sentencing dates after those things are done, and I have available the schedules of the other judges.
I have no intention of doing it.
Is there anything further from the state before we adjourn?
No, Was it clear about our estimation of time from?
I believe you said a day and a half to 2 days.
Yes, that's
And the defense would agree the entire case, a day and a half to 2 days?
With regard to the aggravation hearing, yes.
Yes. It will be both, they will be combined, aggravation and mitigation.
Your Honor, I should inform the court that Mr. Schroeder has indicated, after we've discussed with him how the case proceeds, he would like to proceed with us as counsel at least through the aggravation stage. With regard to mitigation and balancing, he may want to revisit that decision. We may have differences of opinion about how to proceed with the latter stages.
All right.
He also does, I apologize, he also does not wish to cooperate with the pre-sentence investigation in terms of further questioning.
All right, well, I'm going to order one nonetheless, Mr. Schroeder, as I'm obligated to do under the law. You don't have to cooperate, that's your decision, sir, but I still have to get the information together for me and the other 2 judges.
Well, it's my understanding that 11 years ago, back in 2007, when they did one of my first murder case, nothing has changed since then. So,
Well, nonetheless, that's the way it's going to be.
well, that's fine. I just
Okay. All right, and so Public Advocacy Commission will continue as counsel for the defendant. Anything further then, other than that, Ms. Newell?
No, Your Honor.
All right, folks, you are free to go and we are adjourned. If you would do the journal entry?
Yes.
All right, the state will do the journal entry. You may sign off if you wish. Okay. I don't know.